It is not very uncommon that a false or frivolous FIR can be registered against some accused person just to settle some personal score, or by making false allegation just to harass the accused person, or to convert a civil case into a criminal case. And it is also not very uncommon that charge sheets are also filed in such cases despite investigation by the investigating officer of the police department. So if in case a false FIR has been registered or a frivolous charge sheet has been filed by the police, then what is the remedy available to the accused person? Hi, this is Advocate Prashant Kanha, and in this video I'll be informing you about the remedy that is available against a false and frivolous charge sheets or FIRs. The Supreme Court has taken note of these things so many times that it is very common in this country that people file criminal cases where civil cases should be filed, or where even no offense is being made out, or where the person may not have committed any criminal offense, then too, just to settle scores, FIRs are registered. Somebody may be using their political connections, somebody may be using their family connections. Anyhow, the FIR may be registered. So the solution to such problem or such abuse of the process of law and abuse of the process of the legal system is that of filing a case under section 482 before the High Court for quashing of the FIR, or if in case charge sheet has been filed, then the case for quashing of the charge sheet. Now you have to look into the case that if it can be quashed by the High Court or not. So how will you test that whether the FIR or the charge sheet can be quashed by the High Court or not? So for that we can refer to the judgment of the Honorable Supreme Court passed in the state of Haryana versus Bhajan in the year 1992. In that judgment, the Supreme Court has digested and enumerated the principles which guide the quashing of the criminal cases or quashing of the FIR or the charge sheet. So what are those 7 points? Number 1, that where from the reading of the FIR or the charge sheet it is clear that no prima facie offense under any criminal law is being made out. So the first test or the first ground that is available for quashing of the FIR as per the state of Haryana versus Bhajan is that where from the reading of the FIR or from the reading of the charge sheet no prima facie offense is being made out from the facts that are disclosed therein. So let us take an example. Person A alleges that person B took 1000 rupees promising that he will be making 1200 rupees out of it by investing same in the share market. Now he has not returned me 1200 rupees. Even after the expiry of the promised period, please take action against him. Now here it has not been disclosed that how it is a criminal offense. It has not been disclosed that whether any criminal breach of trust has been committed by not investing the money in the share market and investing it somewhere else. There is also not any allegation of any kind of cheating, because it has not been disclosed that by making that the person was not competent to take money or accept money for investment. So these things are also required to be disclosed in the FIR, so that devoid of such disclosure the FIR can be quashed. The second ground which has been given in the state of Haryana versus Bhajan is that where a cognizable offense is not disclosed and only a non-cognizable offense is disclosed, and in that scenario if the FIR has been registered, then such FIR can be quashed. Let us take for an example that a case of adultery has been registered by some person, or a case of adultery has been registered by the husband against the wife, and in that case the police has registered FIR. So this is a non-cognizable offense. In that scenario the case can be quashed by the High Court. The third ground is that where some allegation has been made and evidence has also been given, but even those allegations do not constitute any offense against the accused person. So like I gave you the first example, 1200 rupees was promised. So now if in case he tries to explain that how this becomes an offense, but from that explanation the ingredients of the particular offense or any offense are not being made out, then this is also a ground for quashing of the FIR or the charge sheet. The fourth ground that has been given by the Supreme Court is that where the allegations are so absurd that no prudent man would believe that any offense has been caused there. The fifth ground is that where a non-cognizable offense has been reported and that is being investigated as a cognizable offense by the police without the permission of the magistrate under section 155, then also such FIR can be quashed. The sixth ground that has been given for quashing of the FIR, that where there is any legal bar in registering the FIR and still the FIR has been registered or the charge sheet has been filed. So many a times what happens that the locus for filing a complaint is only given to particular person or where a sanction is required for filing a case. Now let us take for example that offenses like adultery or offenses, personal offenses or offenses relating to marriage can be filed only by the husband or the wife or the first relative or the father of the wife. Now if any person is filing any case beyond that, which are given in section 198 of the CRPC, the limitations are given in section 198 CRPC. So if any person is filing case who does not have the locus under law, then in that scenario FIR can be quashed. Similarly, in cases where sanction is required from the head of the department or from the government, and in that regard if FIR has been registered without taking the sanction, then in that scenario also FIR can be quashed. And last ground is that where the FIR or the charge sheet has been registered with mala-fide intention. Now how will you prove mala-fide? That will be dependent upon the circumstances of the case, and that will also be dependent or vary from case to case. The court has not given any straitjacket formula for determining that, but from the facts of the case and circumstances, mala-fide can very well be revealed. So there are so many examples or cases where such FIRs and the charge sheets have been quashed by the High Court. The Delhi High Court especially has been very proactive in quashing FIRs. So where any of the test or the grounds as mentioned in the state of Haryana versus Bhajan can be proved, then the High Courts don't hesitate in quashing such FIR or charge sheet. However, such powers are exercised in rarest of the rare matters by the High Court. It is you and your advocate who will have to determine that whether it is a good case for quashing of the FIR or charge sheet or not. Now beyond these 7 grounds, there are many more grounds which have evolved during last many years by the Supreme Court, and one of the grounds is that if there is a settlement between the parties during the investigation process, then too FIR can be quashed, and even if charge sheet has been filed, then too courts can quash the charge sheet even in cases which are non-compoundable. So non-compoundable cases can also be quashed by the High Court if in case a proper settlement to the satisfaction of the court has taken place. The jurisprudence has evolved to such an extent that even cases of SC/ST or the cases under SC/ST Act are also quashed by the Supreme Court if it is of the satisfaction that proper settlement has taken place between the parties. So this is all with respect to quashing of the FIR or the charge sheet. Hope this helps. Thank you.